Hello and welcome to Car Dealer Live. My name is James Batchelor and thank you very much for joining us for these live broadcasts on the Car Dealer YouTube channel. Now today we are running one of our legal special shows, or special legal shows, that's the correct way of saying that, sorry, with motor trade law specialist Lawgistics, and joining me as ever is Nona and Kiril. Hello both.
Hiya.
Hi James.
Lovely to have the pair of you on. As always, I think it's a highlight of my month, actually, talking to you two. Actually, it's just nice. It's just nice having some legal support monthly. It really is.
Likewise.
Yeah. Now, Nona and Kiril are going to be answering questions already submitted by dealers. And as this is a live show, you can get involved. We're on there for the next 20 or so minutes. So if you do want to join in, please do drop your questions into the comments box and I'll do my best to ask it to the pair of them. Okay, so really, I think the general theme of the questions that we've got today really are inevitably coronavirus, and there's a bit of sort of furlough scheme as well. Let's start with coronavirus, if we may. Nona, if I could turn to you first of all. We've got a question here from Julie, actually. She says she's got someone who cannot work as their daughter has been sent home from school as a classmate has tested positive for COVID-19. Now, the daughter has to self-isolate for 14 days and her dad cannot get childcare and so says he cannot come into work. What are the options there?
Okay, well, we're having a lot of these sort of inquiries now because we are getting down to the nitty-gritty of furlough and kind of what can go on. But basically, until the end of October, when furlough is going to finish, we think, currently, you can still put people on furlough as long as they were previously on furlough before the 30th of June. Remember, we had a deadline earlier on in the year. I think we said before, people like me and Kiril that worked all the way through, if we're in that situation, director here can't put us on furlough from there. But that still remains an option, and it's an option if there's issues like that with sort of, it's not really a childcare issue, that is kind of a COVID issue. Yeah. Anything COVID related, it's legitimate to put people back on furlough, and that's probably the best option there. Anyone who's still shielding can stay on furlough, or if you're looking after someone that's vulnerable, they can stay on furlough. The other option is if he's got any annual leave, because a lot of people have got annual leave left, you can make him take annual leave from there. And after October, when furlough finishes, you may be having a discussion where they've got to take unpaid leave in those circumstances. You'll have to wait and see what the guidance is. But currently, anyone in that sort of situation where they've got to look after someone, there is an option that you can put them back on furlough. But obviously, it's got to suit your business as well. Maybe the job can be done at home, so there's a conversation to be had at least.
Yeah, and I suppose it's none of this is really helped by the fact that people can't get tests at the moment. So that's adding and people are trying to do the right thing and perhaps saying to their employer, look, I'm suffering from coronavirus symptoms. I sort of need some time off, but I can't get a test to actually prove that. So it's a bit of a tricky one, really, isn't it?
Yeah, it is indeed. But I mean, if they're sick, they have to go on sick. So you can't put someone on furlough just because they're sick.
Yeah.
If the business suits it and they happen to be sick, there's a business reason to put them on furlough, that's fine. But if they're sick, they're off sick and they're on SSP or whatever the company sick pay is from there. But yeah, there's huge problems with testing, and the whole system, as we know, is just how it is.
Wow. Yeah, let's not get into that because we all get quite angry, actually, couldn't we? But there we are. Kiril, can I turn to you, please? So let's stick with the coronavirus theme here. A question from Jeff, who says, I have an advertising contract with a local agency ending next January. I'm not quite happy with them. It looks like their advertising made little difference to my sales. Add to that the COVID situation. Can I use COVID to end my contract with them now?
Well, that is an interesting question. My answer would be, it depends. Generally, there has been some tendency against treating coronavirus as frustration event that would fundamentally undermine all contracts, because obviously it would cause havoc in the industries and the economy in general. So frustration is when someone cannot perform what was contracted. The contract fundamentally, the circumstances fundamentally change, the contract cannot be performed. That's not really what we're dealing here, especially now that the lockdown has been lifted, local restrictions notwithstanding. So having said that, there still may be a possibility to end this contract early, depending on the exact terms and conditions. Well, first of all, there could be an early break clause. I suppose that's not the case, really, but that's certainly worth checking. I would generally say, before you sign anything, read through or have your lawyers check it before you sign. It will save you lots of trouble later on. Another thing is there could be clauses specifying some events as given an option to treat the contract as terminated. Even in the absence of that, certainly for the time that that business was in lockdown, advertising agency was in lockdown, they couldn't perform what was contracted. So at least there should be an allowance for that, a discount or a rebate, something of that sort. But it's hard for me to advise without looking at the terms and conditions as they were agreed, and it's I can't iterate it hard enough. Please read through the contract before you sign, so you know what you're signing.
Yeah, and I mean that goes for everything really, not specifically the times that we're currently living in, really, doesn't it? But
no, not at all. I mean, we had a very recent court decision, which is quite important for the insurance claims. Which highlights again that is the exact wording of the terms is very important. I'm not sure if Nona has anything to add on that. No.
Yeah, you're talking about the business interruption insurance case, Kiril, I'm sure. Yeah, we've had the judgment came out yesterday, I think, from there, 162 pages. So it's quite a lot to churn through. But the FCA, it was a test case that the FCA brought. I think there are 8 insurers involved, a couple of action groups as well. And the FCA, the Financial Conduct Authority, were representing the policyholders, because a lot of people we know have gone to claim on their business insurance, but they've had their claims refused, and the insurers have found some way not to pay out. And this judgment, which the case was going on from June, so it's been going on a long time, but we only got the judgment this week. And that really pins down to the wording. You're looking at, what does disease mean? What's the vicinity? Does the disease have to be in the local area? Some car showrooms, they were on the list that had to close, so their business was interrupted. Yeah. But what about those that did online sales? Was their business interrupted? Are they covered from there? Lots of little subtle nuances. I'll say it's 162 pages of it, with multiple lawyers involved and judges going through it all. But the upshot is, if people have got some sort of business interruption, is normally for sort of physical damage to a property like flood or fire. But obviously people want it to go further than that. So if you've got the word disease in your insurance policy, that's a pretty good start, really. So anything around there. But yeah, if you're finding yourself arguing with your insurers over business interruption insurance, terms and conditions, again, send them over. We'll have a look and find out what the wording is, because I say it took them 8 days to discuss it. So it's not a simple subject. There's not a yes or no answer. It will depend very much on the actual wording. Like all T's and C's, as Kiril said, check your T and C's before you sign up to anything.
Yeah. I mean, we covered that story yesterday, or I think early in the week. And I mean, it's very easy to sort of just, that's another story about coronavirus or a coronavirus themed story, but it's got some serious significances to dealers, hasn't it? Because like you say, I mean, I'm sure there are plenty of dealers out there who perhaps haven't read the terms and conditions in so much detail, or wouldn't be aware of the significance of certain little words. So it's got the potential to have huge repercussions.
Yeah, absolutely. Potentially, if it's prevention of access, if people couldn't access your business, because they referred to a case, I think there was a hurricane, can't remember the name of the case now, but the insurers or the court sort of decided there they couldn't claim because the hurricane didn't hit the restaurant, it hit the whole area. So people wouldn't have gone to the restaurant anyway because the whole area was destroyed.
Yeah.
You know, that's the insurance companies, isn't it? You know, they're not going to pay out unless they have to.
Yeah.
So yeah, there's lots of detail in there, and it looks quite hopeful. I would say it's more hopeful now than it was before the judgment. So the Financial Conduct Authority did a great job, I think, bringing that, and it was put through very, very quickly because obviously, you know, it's a priority to keep businesses afloat. So yeah, if anyone's been turned down, they need to revisit that now and go back to their insurers and look at appealing that decision, because they've got good grounds to now.
Yeah. Well, I'm sure it's an issue we will return to, and of course, you know, if there are any dealers who want to raise that question in something like in a show like this one, then do get in touch, because we're, like I say, it's something we'll probably return to in the future. Let's carry on with coronavirus. Kiril, test and trace. That's 3 words there, test and trace, which have sparked a lot of head shaking amongst lots of people at the moment. We've got a question on that theme here. I haven't got the person's name, but they ask, we are a small family dealership. I've heard that from Monday, the 18th of September, so it's coming up soon, we'll be required to collect customer details for the NHS test and trace service. Will we have to do this?
Yes, James. I mean, certainly test and trace being subject of conversation quite a lot recently. The answer to this is most likely no, because it's only very few businesses which are required to keep those details, and they're the businesses where the customer comes into close contact with the staff when the services are provided, like cafes, the beauty salons, and what have you. So the car dealerships certainly have not of that, so there is no need for that degree of proximity to your customer, is there? If you're going to test drive, it still doesn't count. And generally, that is not, funny enough, that system still remains, well, as far as we know, non-compulsory. So you're supposed to encourage your customers to provide the details for you, because it will help the test and trace system and the NHS in general, have a solid, what have you. But there is no compulsion to do so. I mean, I'm glad to say in our local cafe, where me and Nona go and Polite, we now have a register of people who go there. But as I say, that's not obligatory. Well, having said that, things may change in the future. I don't think it's likely, but there is still that possibility.
Yeah. I mean, I think we've all come to expect the fact that the situation is constantly changing. So
indeed, that's not helping us lawyers, or well, giving us quite a lot of work, but that's where we are.
Yeah, exactly. Can we just talk about lockdowns for a moment? Because and we've had a dealer on this week, Jim Reed, on Car Dealer Live, who, you know, he's in Aberdeenshire, that area where they did have a local lockdown, and of course there's no sort of advance warning of that kind of thing. It just sort of happens just like that. Dealers who are in a local lockdown, I mean, how can they operate? Can they still deliver cars outside a lockdown area, or conversely, can dealers still deliver cars and do business with customers who you know, the customer may be in a lockdown area? Do we know the precise rules surrounding this?
Well, fortunately now, the government has been quite consistent in that area. Traveling for work from and to areas in local lockdowns are permitted. So it's okay to deliver cars into areas in local lockdown, or conversely, or start to travel from the area of local lockdown somewhere else for work purposes. Now, obviously, it will put the customers in a bit of a tricky situation if they're having sort of traveling to Aberdeen from another area because they were attracted by some particular car. But that's down to the customer. It doesn't affect the business. I mean, there's a whole, but we luckily have this certainty that travel for business purposes, for work purposes, is permitted. And frankly, the local lockdowns, yeah, it certainly didn't help that they were announced at the very last minute with no precise restrictions. But generally speaking, the dealerships were, again, allowed to operate pretty much as normal, notwithstanding the requirements on their staff in view of the local restrictions. And again, now Scotland and Wales devolved administrations, and quarantine came under their powers. So we have now different regime in Scotland and Wales and in England, and different regime in different areas in England. Adds to the complexity.
Yeah. Well, we've got an interview with a dealer going into this week's issue of Car Dealer magazine. He's got dealerships in Wales and in Southwest England. So the difference and the stress of having to work out the rules and which rules apply to which business is actually quite difficult. But I won't give too much away. But it's a full interview in the next issue. Anyway, Nona, furlough. I know we talk a lot about furlough. We started the show off talking a little bit about furlough as well. Just as a reminder, I'm sure you're sick of talking about it, but what is happening? Because since we last spoke, the situation's changed a little bit, and it's going to be changing again next month, isn't it? So, I mean, for instance, is furlough definitely going to end next month? What's the situation?
At the moment, Rishi Sunak is sticking with, yes, furlough will end. I think most of that is based on the fact that if people haven't been able to come back to a job by the end of October, there's probably no job there potentially. And I think the Bank of England have said you're sort of funding empty jobs, if you like, and what's the point of that? Let's get to the next stage. So I think he will probably stick to that. But I know the Chamber of Commerce and various business organisations have been trying to talk to the Treasury to talk about what can you do, and there's this sort of short-term working thing that's being put out there. I think in France and Germany they've got schemes where the employer takes them back part-time and the government tops it up, which is not unlike our flexible furlough, I guess, how that's been there. I think there's more and more pressure on the government to do something, particularly within certain industries, not so much perhaps this industry, but obviously entertainment, some of those where they're not really back and they can't go back yet because of the socialising. And well, it's up to 6 now, and it's gone backwards for theatres and things that wanted to get back going again. So I'm sure there'll be something, but as far as we know, the furlough will be ending. I think if the short-term working comes in, I think employers will probably take that as an alternative to the £1,000 bonus that's coming up at the end of January. Remember, that is for employers that have brought people back from furlough and keep them on beyond the Christmas period until the end of January. So I think we spoke before about, how useful is that going to be? But maybe they'll bring in something else and say, well, here's your choice, take short-term working. But at the moment, this is it. You're on 70% this month, and then October it's 60%, and then whoosh, we're off the cliff, and that's how it is at the moment. But I can't see that can carry on.
No, and I'm sort of inclined to agree with you on that, really. But it's interesting that the January, keeping people employed until January, it's gone a little bit quiet. That's not really being sort of shouted about much at the moment. I'm sure it will come back to prevalence soon, but it's gone a little bit quiet. And like you intimated there in the previous show, we have discussed about really is there much use to that? But we'll watch that one. Kiril, a question here from Dave 912. Interesting name, but Dave says we're not back to normal yet, and it may still be quite some time before normality is back. Is there anything we can add to our employment contracts to protect our position? He means furlough and such like. Kiril.
Okay. Well, first of all, just a reminder, you have to provide employment contract on day one when the employment starts now, and it will change in April this year. Not necessarily full employment contract, but certain terms, they have to be provided at the start of the employment. So that's something worth bearing in mind. And also they're being changed again in April, the list of the terms being now extended. But bearing this in mind, yes, there are some things you can include in the employment contracts to sort of provision for interruption in your business continuity. There will be some instances you will not be able to provide your employees with work. So the whole position is the employee will have to be ready and available for work. The employer will have to provide work. Well, an employer will be well advised to include, say, short-term or layoff provision in the employment contract, say, we have it instead in our HR manager. But on top of this, you see, we're living really in a precedented time, and the furlough scheme, I don't think, not just myself, but my legal colleagues, but just haven't seen anything of that sort in the past, even some distant past. So as long as the employer will include some clauses regarding interruption in business continuity, absence of work, yes, there may be a general clause that if there is a scheme like furlough scheme introduced, then that will be basically introduced to you on the terms as the government will advise at the relevant time. But as I say, it's difficult to advise in precise terms as long as there is some provision for business interruption. That should be sufficient.
Okay, we've got a question here from Anonymous, actually, and it's a question that I know a friend of mine will actually want to know the answer to. So I hope they're tuning in. Probably not, but there we are. They ask this question from Anonymous asks: I still have people on furlough, and I'm worried about them all wanting to take annual leave when they return, especially as I already have people currently working who also have a lot of annual leave left. What is the best way to manage this? Nona, what do you think about that?
Yeah, well, I think a lot of people are going to have that problem. And I think when we were on these shows, we were encouraging employers to make their people that were on furlough take annual leave while they were on furlough. Because, of course, you can force someone to take annual leave as long as you give them enough notice. And it has to be twice the length of the annual leave period. So if you want to make someone take 2 weeks leave, you need to give them 4 weeks notice. So I think a lot of our clients did that, so they're perhaps not in this position now, whereas a lot of employers will be.
Yeah.
What do? I mean, the annual leave can be carried over for up to 2 years, so that helps. But it's probably useful if the employer puts some sort of policy together, and so they make it clear. So perhaps in the policy they might want to say they will prioritise leave for people that ask who have worked all through furlough. Because those of us who worked all through furlough, we feel like we've worked very hard and perhaps we deserve the leave. So you might want to do that as a policy. There's nothing wrong with doing that. So you can say that. And you probably want to put in that policy, if you're going to do that, about people that choose to go abroad. Because at the moment you could go abroad and you don't have to quarantine. You could be out there and then the news comes that you do have to quarantine. So people are taking a risk if they go abroad. And perhaps employers need to say, if you want to go abroad, that's obviously your choice, but you need to tell us where you're going. And if the quarantine comes up, we're going to have a chat when you come back. And if you can't do your job from home, you'll either have to take leave for the 2 weeks quarantine period, or you might be unpaid. And I think as long as the employer makes that clear. So I would suggest people sort of put some sort of policy together. Makes it quite clear, because otherwise there's the potential for saying, well, he's got leave, why haven't I got leave? And people don't really know what to do, and particularly with the quarantine. I think going abroad, because that will be an issue as it goes on, and different countries come in and out of the quarantine rules. Yeah.
Well, it's the holiday issue is something I'd like to return to in a second, but just to sort of interrupt the sort of the holiday theme, we've got a question here from James Baggett, the boss. It's very nice of him to actually join in. Hello, James. Nice of you to join in. He says, following our story on short-term working scheme this morning, what is Nona's thoughts on the chances of a scheme replacing furlough at the end of October? I know we were just talking about earlier on that we think it is going to end in October, but do you think there could be something that is sort of like furlough Mark II, but is not actually sort of furlough? No.
Yeah, I think so. I think, as we said, you look at what France and Germany are doing, I think those schemes are going quite well. So I would think, and the pressure is building and building on the government. I think maybe they thought, I mean, what we're talking March or April, they put sort of furlough in, didn't they? And then perhaps they thought they'd have it under control. They might have thought they'd have a vaccine. And if the test figures are to be believed, I say that, things are getting worse. Are they getting worse? Are we covering up Brexit? Who knows what's going on there? But, looking at the test figures, we are perhaps going into a period where COVID's going to get worse. And if that's the case, then they've got to have some sort of economic answer to that, I think. But we're obviously juggling quite a lot at the moment, Boris and his gang, so we will see. But I would hope to see something for sure, and I would think we will get something, but what, who knows?
Yeah. Now, that is a very good point, because, of course, the furlough scheme was laid out in March or April, and, of course, we're in a very different situation as to where we are now. You're right, there could be a second wave, and of course the whole job problem comes back again then, doesn't it? So it's going to be an interesting one to follow there. Kiril, can we just talk about holidays? Because I know we sort of started to talk about them there. We've got a question from Stephen here who says, can I stop my staff from going on holidays abroad? And if they have to quarantine when they come back, do I have to pay them?
I think I have to agree with Nona here. First of all, the employee will have to talk around this issue. So if you're normally going on holiday in an area where you have to quarantine and coming back, well, make sure that it doesn't disrupt the business and your employer can allow it. And you have sufficient, say, leave days to cover for the quarantine period as well. I think the most difficult will be in cases when someone goes abroad and then all of a sudden this area falls in quarantine regime and they will have to come back and quarantine. Obviously, they can work from home, great, but what if they can't? Well, one thing is quite clear, we'll say sufficiently clear. The current official advice from the government and makers says that SSP cannot be claimed for quarantine, so SSP is not an option. Although if you look into black and white law regulations, there is an issue of deemed incapacity, which can be due to enactment of government notice and what have you. It is currently considered not enough to trigger the entitlement. So SSP is not an option. So we're down to taking annual leave if there is annual leave left, unpaid leave if there is no annual leave left. There have been discussion, what if someone, well, if we can be dismissed if they're under 2 years of service and they have to quarantine if they're coming back. I would say it's a drastic action. It's true to say that under 2 years of service would not be entitled for unpaid dismissal in most circumstances, but in some, most generally discrimination, but it also could be health and safety, which reverts around COVID issues. I would say it's actually a drastic action. And if someone was to dismiss someone because they have to quarantine having come back from their holidays, certainly talk to a lawyer before you do that. So I would say safer options would be take annual leave if you have one left, or if you don't, perhaps an unpaid leave should be an option.
Yeah. Brilliant. I'm sorry if I was smirking a little bit during that. It's just that a slight technical issue there where the screen was cutting to Nona whilst Kiril was talking. So Nona, it was great. I mean, you were doing a great job at talking and your lips weren't moving, but there we are. But anyway, Kiril, I've got another question for you here. They say, I have a new starter. It turns out she has COPD and has got a sick note from her GP. As she says, it is not safe for her to work in our reception. Can I terminate her employment?
Well, alarm bells go off straight away. COPD, chronic illness, disability, and it will be very difficult to argue that she is not dismissed precisely because of her disability, which is automatic unfair dismissal and discrimination claim two together. So I would certainly advise against that. But having said that, there are things that the employee can do. Well, for example, if the GP says that the GP considers not safe for that employee to work in the reception area, well, why is that? Was that the GP know about the layout in the reception? If the place is COVID secure, if the workplace is following the official guidance, there is nothing to say that people who would previously were told to shield cannot return and start working. So I fully appreciate that the employer will have a problem here because, yes, you perhaps are knowledge of an employee with a chronic medical condition, but the employee is now put a notice of that. So I would certainly say dismissal, not something I would recommend, but other things like requesting a medical report to clarify what's exactly the difficulty here. And generally, I say people who were previously told to shield can now return to work. So is there something specific or is it just general worry that there is big potential exposure and the place can be potentially risky? So I think it could be resolved without resorting to dismissal.
Okay, brilliant. Final question here, actually. It's a bit of a change of tack, but Nona, if you could help out with this one. It's quite a prevalent issue, this, actually. I've been hearing lots of dealers have been suffering from similar issues. is to do with auction companies. And of course, I think it's been exacerbated by the fact that they've been online only throughout lockdown. Question here that's come in saying, I purchased a car from an auction recently, and during preparation, it became apparent it had been clocked. The auction house say it's too late to complain. This cannot be right. Question mark, exclamation mark. Where do they stand there?
Yeah, I think we are seeing more complaints about auction houses at the moment. I don't know whether the good cars are being siphoned off to different companies, or there's just less prep or less supply. Whatever the issue is, we are definitely seeing a bit of a rise in issues from auction places from there. And a lot of them will have some time clause in there. They will say you have to report it within 48 hours or 3 days. Again, we go back to what we've already discussed. Check the contract, make sure you know what the rules are when you're buying. But something like that, if you take the car away and you don't prep it for a couple of days and you've plugged into the ECU or wherever you've downloaded the history from, and then you find out it's been clocked, the auction house could turn around and say, well, it's in our terms and conditions. You had 3 days to return it and you're past that. We would look to override that. And if it's been represented, particularly if the mileage has been warranted, we would say, well, you've described it, you've represented it as warranted mileage, it's misdescribed. It's misrepresented, so that can override the terms and conditions. Because yeah, terms and conditions, generally business to business, you're kind of stuck with them, but there are always caveats to that. And certainly, you know, get legal people involved, we can probably find a hole or something to go over that. But you shouldn't end up with a car that's been clocked. And I say there are all sorts of issues at the moment. So it is a big theme, you're right, that's going on with the auction houses, and we're getting involved quite a lot. We do get them resolved, generally speaking, but the auction house's first point will be you're too late, you're outside your 48 hours or your 3 days or whatever, but you know, keep going.
Yeah. Brilliant. I think we're going to have to leave it there, I'm afraid, Nona and Kiril. We haven't got through all the questions, but perhaps we can save some of those for next time. But as ever, some fantastic advice there. So thank you so much for coming on.
Thanks, James. It's been great.
So if you want to be involved in a car dealer life just like this one, then please do get in contact with me, james.batchelor@blackballmedia.co.uk. That's my email. Or you can contact James Baggett. He's available at james@blackballmedia.co.uk. We're back on Friday, but until then, thank you very much for watching, and bye-bye.